Welcome to Immigration Talks by the American Bar Association, Commission on Immigration, and the Civil Rights and Social Justice section. My name is Emily McCabe, and I am pro bono counsel at the ABA Commission on Immigration. And today, we'll be talking about the frivolous asylum application. The finding of a frivolous asylum application results in an applicant becoming permanently ineligible for any benefit under the Immigration and Nationality Act, aside from a mandatory grant of withholding, if the applicant received notice of consequences for filing a frivolous asylum application. The applicant will also remain eligible for protections under the Convention Against Torture, such as withholding of removal and deferral of removal. And a quick note here is that many circuits hold that the written warning in the instructions for Form I-589 application for asylum is sufficient notice. So, what is a frivolous asylum application, and what is the standard required to make a finding of a frivolous asylum application? 8 CFR Section 1208.20A1 explains that an asylum application is frivolous if any of the material elements in the asylum application is deliberately fabricated and the immigration judge or the board is satisfied that the applicant, during the course of the proceedings, has had sufficient opportunity to account for any discrepancies or implausible aspects of the claim. Thus, a frivolous asylum application essentially concerns knowingly providing information about a core part of an individual's asylum claim. In matter of YL, the Board of Immigration Appeals created a 4-part test to determine if an individual filed a frivolous asylum application. The 4-part test has the following requirements. Number 1, the respondent must receive notice of the consequences of filing a frivolous asylum application. Number 2, the immigration judge must make a specific finding that the non-citizen knowingly filed a frivolous application. Number 3, there must be sufficient evidence that a material element was deliberately fabricated. And number 4, there must be an indication that the respondent has been afforded a sufficient opportunity to account for any discrepancies or implausible aspects of their claim. In summary, a frivolous asylum application is not a case that lacks sufficient evidence or, for some other reason, is ultimately unsuccessful on its merits. A frivolous asylum application is a case with a deliberately fabricated material element. Do not confuse the layman's definition of frivolous with the definition provided by the regulations. Thank you for your time and attention, and please follow us for more content.